Hi, I want to talk to you just for a moment today about what happens if somebody has a relatively small estate and how that can be handled relatively simply. There are times where somebody passes away and they don't have a will, don't have a trust, but the assets they own are relatively small in value. In California, the magic number that we look to is $150,000. California law tells us that if the estate is worth less than $150,000, there are tools that we can use to avoid probate in order to obtain access to those assets and to distribute them properly to the rightful heirs. For example, somebody has bank accounts, cars, or personal property, and these assets altogether add up to less than $150,000. There is a document called an affidavit of small estate that can be prepared typically by a lawyer. It's very inexpensive to prepare, but this two-page document is signed by the person who has legal responsibility for the estate. So if there's no will, then we're talking about a person most closely related to the person who's passed away in most cases. So that person will sign this affidavit. The affidavit has to be witnessed and signed by a notary. And this document, combined with a certified copy of the death certificate, can be presented to the outside world, like to a bank or to a brokerage company, to confirm that this person has passed away, that their value of their estate is less than $150,000, and this document will be honored under California law to free up this asset to make it available for distribution to the next of kin. So something else to keep in mind in those rare cases where somebody has assets of limited value, there's no worry about having to go through a formal probate action that can take several months, as I've spoken about already. Do keep that in mind if that circumstance comes to your attention. Thank you.